Good morning, Mr. Fallon.
Good morning. Richard J. Fallon for defendant appellant Martin Guy. Now, DNA evidence is the nuclear weapon of evidence, and that's as it should be, because done correctly, DNA evidence is essentially irrefutable, and that's why we have an innocence project nationwide on DNA. Odds such as 1 in 268 trillion are basically saying it's definitely this fellow or definitely not fellow. Now, the essential point, I think, where the Commonwealth and defense disagree is the Commonwealth argues that because this is impeaching credibility and because these reports, the Vance report and Justice Department audit report, did not point to any mistakes in this case, they should be treated as irrelevant. And, Your Honor, I would suggest and argue that when we're talking about scientific expert testimony, when talking in that context, it's quite different than impeaching credibility of laypersons. And in my reply brief, I pointed out the Meggs Appeals Court case and the Lefebvre case of proving that, implying, I suggest, that it's quite a different thing, as it should be, because it undermines the whole scientific issue.
Well, the issue is not whether it's relevant. The issue is whether, as newly discovered evidence, it is so important that it justifies a new trial.
Yes, Your Honor.
What is it about either of those reports that if you had them in hand and were cross-examining Mr. Pina, that would have been so important, since after all he did was send the materials to Maine to have somebody in Maine conduct the DNA investigation? What could you have done with that on cross that would have been so important as to support a new trial?
Well, I mean, if we don't, to be very, what we do know, and the Commonwealth points out that the criminalistics unit sent much of material.
That was in the judge's findings, I think.
And
the criminalistics unit, no, I'm sorry, it was in the judge's, in the DA's, you're right. The criminalistics unit, not the DNA CODIS units, was involved in transferring the evidence to the main laboratory. And wasn't the examination done, the report done on the DNA CODIS units?
however, I do want to point out, we have a pen.
Yes, no, yes,
Oh,
no.
most of the material, for example, the bra cutting. The key point, the
No.
DNA.
Was the report that was done, the reports that were done, were they done about the DNA CODIS units?
Yes, Your Honor.
Okay, and was it the criminalistics unit that was involved in transferring the evidence to the main lab?
We don't know about the saliva sample, which is the key one. We do know about the bra cuttings. It's unclear what happened, and that's why I pointed to appendix page 17. What happened was, in August of 2003, the CODIS unit, Mr. Pina, he pointed to Martin Guy. That was the first time Martin Guy was pointed out. And so he writes a letter to the main lab. And then a couple of weeks later, a DNA sample, a saliva sample, is sent to the main lab. And the DNA analyst in the main lab, Mrs. Colicchio, and I think it's for...
Was the DNA sample sent by the criminalistics
We
unit?
don't know. She says it was taped at transcript 4103. She says it was taped, sealed, and labeled, just as all the other evidence from the crime lab. So it could well have been sent by the DNA unit or by the criminal. We don't know that, Your Honor. But I would argue the key point, and I'll explain why I think it is key, is that this DNA unit is the first one to identify Martin Guy as the person. I mean, he wouldn't have been involved except for this identification. And then
So
you
what?
may ask...
So what? Whatever name John Smith they give to Maine, it's Maine's work that establishes whether it's Martin Guy or John Smith.
Well, and I was going to say, you may ask, well, what's so significant about pointing to someone first? And I would suggest that this case is a perfect, marvelous example of what's so significant about it.
But it wasn't at the Maine lab that came back and said it wasn't Edmund Burke?
Oh, yes, Your Honor.
So
And
it's
the
the
main
same
lab did the DNA.
So the Mass lab gave Maine Edmund Burke, and the Maine lab said no. So then the Mass lab gives the Martin Guy, and the Maine lab says yes. So the inefficiency of the Mass lab doesn't apparently affect the Maine lab, based on this case.
Well, based on this case, though, I would suggest in expert testimony, we have a situation where when the Commonwealth thought it was Mr. Burke, we have their forensic dentist saying, oh, yes, that bite mark is Mr. Burke. And my sister and brother-in-law are dentists. They're not witch doctors.
Yeah, but that's not...
And then we have when we have a second, when the Commonwealth changes its mind and now it's Mr. Guy, We have the second expert at trial, Dr. Reasoner, saying, yes, this bite mark, I'm an expert, and I'm a...
But what does that have to do with whether the code is...
It shows, the argument is, it's very important who's identified as the
Okay,
person.
and get back to Justice Gans's question, which you never really answered. How are you going to get this evidence in a trial? In what form would this be admissible evidence? You can't just put in a report.
Your Honor, I suggest they're admissible for two respects.
No, how are you going to get it in? You can't get in a report.
Well,
You
you
can't
could-
put a piece of paper in.
Right, you could bring the person who wrote the report and to testify, yes, this is a report, this is my report, and I believe you can get a piece of paper in as hearsay exception on two respects, Your Honor. I would argue the vicarious admission of a party opponent issue
isn't the party
and the official report issue.
But well, how does it get to be the party opponent here?
It's the Vance report was an agent of the Commonwealth, number one, and I would suggest the Justice Department was an agent of the Commonwealth. Pardon me?
Wasn't it an independent examination?
Well, hired by the Commonwealth, by the executive office. I mean, it's very clear. It's hired by the Commonwealth. They're an agent. It's a vicarious, that's why I said vicarious admission of a party opponent.
But I'm still trying to figure out the logic of how the so-called incompetence of the mass DNA unit could have resulted in the error that brought Mr. Guy before the court. They send the bra cup to Maine. You would have to say that they put Mr. Guy's DNA on the bra cup before it was sent
No,
to
Your
Maine?
Honor, and it's a good question because, as I said, that we're not even sure the DNA unit did that, Your Honor. The issue is, and the Commonwealth says it's rank speculation. I admit I don't have a particular point that I can point exactly to, other than the point of August 2003, it's identified at first by the DNA unit. September 2003, they get a sample in Maine from the crime lab. They don't say who in the crime lab, saying this is Mr. Guy's DNA sample, saliva sample.
So then it wasn't that they put the guy's DNA on the cup, but
No,
that
no,
when
no.
but that when they sent what was the known sample from Guy,
And I can't,
That it was
it's
somebody
not
else's?
100% on the record, it was the DNA unit, Your Honor. But, Your Honor, I would suggest that the bottom line is here, let's say this information had come before the court. I would suggest what would a smart prosecutor have done if these reports, let's say these reports came in. And if I can do a very quick aside, when I said official reports, Your Honor, I think you should clear up, it's not really a key issue in this case, but the issue of whether factually based conclusions and opinions are admissible under 803A proposed mass rule of evidence. Handbook of Massachusetts evidence says yes, they are, and cites to the proposed mass rule. And the Herson case cited by the Commonwealth says no, they aren't, and says proposed mass rule, even though identical to the federal rule, should be interpreted different, and goes back to the Slavsky case of this course in 1923. So it's really time to decide that issue of whether you're going to follow the federal. You should be the ones to say whether you follow the federal law.
Now, you knew about the DNA samples before trial, or the defense lawyer did.
Yes, Your Honor.
They could have been subjected to testing by the defense.
They could have, and Your Honor, I would suggest in a civil case that would be a very powerful, point for the party. But Your Honor, this is a criminal case where the other side has the burden. I mean, we shouldn't be saying, oh, well, you could have proved you. I agree.
No, but you're in a
we
motion
could have
for
done
new
that.
trial, but
Yeah.
you're in a different posture now on a motion for new trial where the burden is with you.
I mean, doesn't it seem logical, just to follow up on that, that if you're saying you can't trust this evidence because, it's such a, its performance, the lab is so lackluster that who knows whose sample they put in there? Well, wouldn't the logical thing to do is to test it?
Well, Your Honor,
Very easy to find out if it's his sample.
again, I hear exactly what you're saying, Your Honor. But the point is, we don't know. We can't say exactly what our errors were made. We don't know. For example, I mean, you're right.
Yes, but when
That's
you
assuming if, no, you're right. That's assuming if the error is the DNA, the DNA sample sent to
Well,
Maine.
there are only so many errors that could be made. I mean, it could be somebody else's bra, I suppose. Wouldn't really matter. Right? And it isn't his DNA. That's all that Massachusetts lab could have done wrong.
Well, I noticed the report that presented by, and I put the supplemental appendix, presented by the Commonwealth in the supplemental appendix, put some additional paper. They note the relative ease which with DNA evidence can be mishandled. I agree. I can't point to an exact thing other than that possibility of the DNA sample, and even I can't say for sure that the DNA unit
But
handled
on a
it.
motion, when you're seeking to overturn a verdict, isn't it relatively easy for you to establish whether this was his DNA or not?
Well, Your Honor, I don't think I have to do that.
Well, just like we say
I'll
when you're
explain
seeking a motion for new trial, why isn't there an affidavit from trial counsel? And we hold it against the defendant in those circumstances, and I think that that's a legitimate question.
I mean, you're right. That would be a separate thing, and hopefully we wouldn't be here if we had a DNA test that said it was not Mr. Guy's, that we had a sample. The Commonwealth, I don't think we'd have to be here. I agree.
But going back to those reports,
If I had
as far as I can tell, the best the reports say is that there are some people who, that there may be some false positives and some false negatives with regard to a CODIS hit.
Yeah, yes, Your Honor. That's the audit department. But what the Vance report, what I find very powerful is the Vance report saying that they put the incompetence and the unwanteds in the DNA unit.
I understand that, but there still has to be some process by which Mr. Guy is the unfortunate victim of somehow having his DNA identified as being on the bra cup. And it's that process which I don't understand, because
Yes.
it's not
No,
as if they relied upon the CODIS hit alone.
And
They then did a separate sample was sent, a known sample, and that was specifically analyzed.
I think, put it this way. Everybody understands there's a risk of error in any organization in the handling materials, et cetera. But we also sort of assume, especially with expert testimony, that there's kind of a minimal level of what's going on you assume that the people here who are arguing murder cases are minimally competent. But if you had a trial of a first-degree murder case, where somebody else already had been arrested and there was a lot of evidence, and you found out that CPCS had appointed the most incompetent attorney they could find, that would be enormously problematic, especially in a trial situation.
So we've got here about a 1.5% error rate, isn't that right? 3 in 200?
Yes, Your Honor.
It isn't very big.
Well, that's my argument. It's enormously big when DNA is the nuclear weapon, and when we have a situation where the expert witness for the Commonwealth had said it was Mr. Burke, where the police dog had trailed the evidence to Mr. Burke's house, when Mr. Burke had said very, very inculpatory statements, and when his mother had said very inculpatory statements. And I think this case...
Is part of your argument that it has nothing to do with Mr. Guy, but that CODIS messed up with respect to his samples? Is
No,
that-
but part of my argument, I think very important is this case, that there are two aspects in this case that don't exist on other cases.
Yes, that there's a possible third-party culprit, and that
Right.
the Commonwealth's other evidence incriminated.
Yeah, and very much more than possible, I would argue, Your Honor. And that Mr. Guy wouldn't have been involved at all without the DNA. It just makes it very, very important. And if I can turn to the closing argument, because I think they connect a bit, if possible. The closing argument error here, and the Commonwealth reasonably agrees that it's error, but says it's not prejudicial, is that the prosecutor asked the jury to give an answer to the husband, the grieving husband, to the witnesses, and to the people who walk in the neighborhood. Now, this is even worse than just sympathy, than say sympathy for the victim, because the victim can't be healed or helped by the symptom. This is saying, you can help these people. You can heal these people. You can give them an answer. I argue, Your Honor, that that's extraordinarily prejudicial. And there was a Wallace Appeals Court case, a 1998 case, where defense counsel, prosecutor argued to help the people in the neighborhood. And the court said, well, I overturned, but there were forceful instructions. And I went back and looked at the Wallace case, and they were right after the instructions. And in fact, the judge said, well, both the Commonwealth and defense counsel, mentioned the neighborhood, talked about the effect of the verdict. And that's just enormously prejudicial. The instructions here did talk about the effect of the verdict, but they were an outline. They were given to the jury an outline, and they were obviously prepared ahead. There was no specific address. Now, why I want to bring this up, and I think they interact, is the Commonwealth, part of its argument, says, you know, it says, well, yes, it's an error, but, you know, the evidence was overwhelming here. And, you know, I think the Commonwealth, in a way, is taking two different positions. Because in this sense, they're saying, the only way you can say the evidence is overwhelming when you have an expert witness of the Commonwealth say it's somebody else, and when you have all this evidence say it's somebody else, is that if you think, you know, DNA evidence is the nuclear weapon, if it obliterates everything else. But if you say that, then when this risk of error being completely different from what one would expect. In other words, one would expect that the DNA unit would be highly skilled, the best people would be in the DNA unit, because that is the nuclear weapon of evidence. That is the most reliable. You want to have the best people in there. You want to have it 1 in 268 trillion, not 1 in 100. And that's the real problem. I agree. We don't have a specific thing we can point to that's where they made a mistake. If we did, of course we wouldn't be here. The Commonwealth, one would hope the Commonwealth would say, okay, DNA, we blew it and such. But where the jury had to find beyond a reasonable doubt in this context where there's someone else. And that's what I say. I think they both interact. If you say it's not, you know, it's not, DNA is just evidence like anything else, then I think my argument on the closing is very strong. Because it isn't, the evidence definitely isn't overwhelming. You have another person arrested with a lot of evidence. If you say, I'm sorry.
Back to the report.
Yes, Your Honor.
The judge went through all the errors that the report found, and without bothering to list what she said,
Sure.
Her conclusion was that none of these errors is of the sort that could result in an erroneous match, which would be the only type of error that would have any bearing on evidence presented at trial. So what do you say to refute
Well,
that?
I think erroneous match is kind of an ambiguous term, Your Honor, to say. Erroneous match in the sense of 1 in 268 trillion, I think for practical purpose, isn't going to happen.
No, the
But-
errors that the report found were failure to document confirmation of a match in one instance, delay in confirming a match in one instance, delay in forwarding the results of an evaluation, incomplete profiles, and an error in uploading one profile and an uploading of one profile under 2 identification numbers.
Well, I would suggest...
None of those, she says, could result in an erroneous match, and that's the, and they didn't even do a match. So I have a hard time seeing how anything, even if you got the, how the report would be relevant to this case.
Well, Your Honor, I suggest that the uploading profiles under different identification numbers, while that might not in that particular case, that's an enormously damaging thing, that they're messing up the numbers. That's really the bottom line, Your Honor, I would suggest. And let me go to the report, because I think there were very serious, it's appendix page 53, because there were the very serious 100 profiles. One profile was inaccurate because the value uploaded, this is A56, Your Honor. One forensic profile tested was inaccurate because one of the values uploaded did not match the value identified. That's it. That's the error. That's terrible. That's going to be the wrong person. And then this next one forensic profile we tested was both inaccurate and incomplete. The officials incorrectly entered the same profile under 2. So that's 2 out of 200.
But they didn't do any testing here.
Pardon me?
But they didn't do any testing.
Yes, Your Honor, I agree. It was the main. There's no question about that. You're right. It was the main, but they were the first one to identify, and I have to say, this is why medical people talk about blind testing, double-blind testing. And this is, of course, the problem in all the eyewitnesses. Because medical people do double-blind testing. Because if you think you know the answer...
But your argument is absolutely refuted by the fact that Massachusetts first sent Edmund Burke's name, and Maine said no. So in this case, the
that's
fact
one.
that
I
Maine
agree.
knew who Massachusetts thought it was is just absolutely kills your argument.
Well, it doesn't kill it, Your Honor, because that's only 1 out of 2 sections. So if you could sort of say, well, that argument says, well, you have a 50%. We don't want to have a 50% accurate. But I agree that that's an argument that, well, they're not always at the DNA plate. But I don't think I have to say that they always got it wrong once they identify. I think what I just have to argue and win on is that there was a serious difference between the reasonable expectation of the jury. As I said, we all know everybody makes errors. But there's a serious difference between the reasonable expectation of the jury's view of the DNA unit and this whole process, as opposed to the reality. And the key thing is that the key thing, and I have to say, I think the Commonwealth downplays it, and I can understand it, but it's just perverse to put the incompetence in the DNA unit. It's just like if CPCS said, oh yeah, let's get the most incompetent people and do the first-degree murder trials. It's horrifying. If you don't have any more questions, Your Honor, I'll rest on my brief. Thank you very much.
Mr. Shannon. Good morning, Ms. Alford.
Good morning, Your Honor. On behalf of the Commonwealth, Pamela Alford. The Commonwealth requests that this court affirm the judgment, the conviction of first-degree murder, and the lower court's denial of the defendant's motion for new trial. What is critical in this case is even if you accept the defendant's argument, to even look at the studies, which the Commonwealth says that you should not, there were a number of different, that this evidence was, the CODIS evidence was cumulative. Because
I'm sorry, was what?
Cumulative.
Cumulative.
Because first, you had the match that the defendant places so much emphasis on was a match between originally a 9 loci profile from the state CODIS administrator and a sample of the defendant that was taken from MCI Concord staff and was analyzed by Cellmark, now Orchard Cellmark, not the Commonwealth of Massachusetts State Lab. But even if you...
Excuse me, analyzed in the sense that it went into the National Data Bank? Or
no,
with respect to this?
Analyzed in the sense that at that point, the state lab was sending out those types of samples to a contractor. So that Cellmark did the analysis of the defendant's CODIS sample. But even if there's some issue with that initial match, there then was a national match when the defendant's CODIS sample was uploaded nationally. It matched to what Teresa Colicchio had uploaded in the state of Maine. And even if there is some inference that there was a problem with the CODIS match, you then had a separate sample taken from the defendant, I believe it was by a Massachusetts state trooper, that Teresa Colicchio of the Maine State Police Crime Lab analyzed, matched against the interior right cup cutting of the victim's bra, known at trial as item 6A, and it was that evidence where the 1 in 268 trillion statistic came from that the jury had the ability to look at. That was the critical evidence before the jury. The CODIS evidence was merely to give the jury a sense of why we were here. But the statistics came from a match that the Maine State Lab did both the defendant's sample and item 6A.
So the CODIS thing it was essentially part of the background investigation.
Correct. And even if you accept the defendant's argument that that's how they initially looked at the defendant as a suspect, which I would say would be correct, the defendant would have been looked at as suspect in any event, because when his sample, CODIS sample, was uploaded, there was a hit to Maine sample, which was uploaded in the national database. So there's very little that Massachusetts had to do, particularly on cross-examination. I believe it's volume 4.
So you're saying even if it were some error, it would be harmless. It wouldn't make any difference because eventually his sample was going to come up through the national database as matching the sample in Maine.
Absolutely. The only thing that Massachusetts did was enter that numerical profile.
When did the defendant's DNA profile get into CODIS and why?
That is in an affidavit that the Commonwealth submitted in its opposition to the motion for new trial. The defendant's sample was entered into CODIS on June 17th, 2003. I don't know that it's explicit from the record, but we do say at paragraph 4 on supplemental appendix 39 that the sample of the defendant's DNA was taken by staff at MCI Concord for inclusion to the CODIS network.
Having nothing to do with this case.
No. Inferentially,
It was an independent crime, or?
the defendant had a previous conviction.
Okay. And that's where they got his sample that provided the DNA information that was entered into CODIS.
Yes, to the best of my knowledge, it was due to the taking of his sample by MCI Concord staff, sending it out to Cellmark, and then entering it into the CODIS database.
Now, let's speak briefly about the chalks that went to the jury. Was there any objection to these chalks going to the jury during deliberations?
Yes, I believe there was an objection to them going to the jury. There was not an objection, however, to the judge's instruction at the supplemental juror question that the defendant alleges there was some confusion. And I think what's important to notice about the charts is that the defendant makes an assumption that I don't think is an appropriate inference, which is because of this jury instruction and because that the binder was a chalk, the jury would have assumed that because they had it and they were told they didn't have chalks, then it must be evidence. Well, this binder wasn't treated as evidence. It wasn't marked for identification in front of the jury. It didn't go to the jury with the rest of the evidence. It was treated much more like one of their notebooks. This was a binder of just raw DNA material that they could use to follow along with a more animated presentation that the Commonwealth used during the DNA presentation to really focus in the jury's intention. And it's appropriate both on the issue of the chalks and on the issue of that Maine knew that Massachusetts first thought it might be Edmund Burke or proffered him as a suspect, that there were more than just Edmund Burke and Martin Guy in terms of DNA that was before this jury. There were numerous suspects through the years between the exclusion of Edmund Burke and the CODIS hit in 2003, and the Commonwealth talked about that and went through the various suspects and why the various suspects did not match, which is both important in terms of the chalks because these chalks were concise schedules, just raw DNA material that the jury could scarcely be able to contain in their head, and also because it buffers the argument that, it counters the argument about double-blind testing. Not only did Maine know that Massachusetts had proffered Edmund Burke, but there were all these other suspects. This evidence, the two reports do not require a new trial. This is very similar to both the Lefebvre and Schumann cases, which talk about expert studies, in that there is simply not enough to have an expert study that perhaps you would have liked to have had before the trial. The defense cross-examined the state police employees, cross-examined the lab employees, both about the handling of the evidence, and cross-examined the CODIS administrator about a perceived error he had made in a timeline and suggested that shows sloppiness or lack of care. And there's absolutely nothing in either report, the OIG audit or the Vance report, that relates to this case. And in that event, I believe it's Commonwealth versus Ellis is particularly on point. That it's just not enough to say that there might have been misconduct someplace else. Ellis was a case where you had two police officers who were involved in an identification who, one, I believe, pled guilty to charges akin to corruption. The other was not charged but admitted it and cooperated. And this court held, well, that's not enough. I also refer your honors to the appellate court case of Commonwealth versus Cruz. In that case, the appeals court held it was not error to preclude the defendant from cross-examining medical experts on isolated mistakes not related to this case. And to counter the defendant's argument that DNA is different, I would suggest, Your Honors, that you have already held that DNA is not different. I would point you to Commonwealth versus Matthews, which talks about an inconclusive DNA a DNA match. And in a footnote, you talk about, citing Canavan's case, that scientific studies are no different than any other evidentiary determination that a judge makes. And I think it's important in looking at the judge's finding that Justice Cowan pointed out that this was the same judge, both the motion for new trial and at the jury trial. This judge was particularly attuned and should be granted particular deference into how these reports would have affected the trial. And the Commonwealth suggests where the reports do not address anything that was done at trial and do not address the lab that did the analysis, that they're not relevant, that they would be confusing to the jury.
Could I ask you a question on a different subject, please?
Yes.
What was the relevance of the fact of those magazines and books that were found in his house? Don't lots of people these days watch crime and detective movies and television programs and have books and read books like that?
I'm sure that they do. I think you could make an
Doesn't make
inference.
them serial, so I don't see the probative value of
Probative value goes to state of mind, goes to the number of books, the fact that these were read frequently, not that this was a subject that the jury could infer that he had great interest in, that he was focused in. It goes to a state of mind, and I would point this court to Commonwealth versus O'Brien, which discussed this, in Commonwealth versus SOC, S-O-K, which also discussed this. There was evidence that came in through Scott Davis that the defendant had indicated that this was a thrill, and these books aligned with that evidence to show that there was that to explain what otherwise could be unexplainable.
Okay, I'd like to go back just a minute to the chalk.
Yes.
Is the chalk in the record anywhere, or is there a picture of the chalk in the record?
The chalk was the chalk is a binder.
Okay.
It was not entered into evidence. It was marked as for identification letter P.
For some reason, I thought there was some reference to it being a blackboard. That's not right.
No,
it was a handout.
It was a notebook, I assume.
It was a
notebook handed to the
Okay.
jury.
Yeah,
which the
it was a
jury
binder.
used.
It was about a 1-inch white binder. Every juror had a copy.
And the notebook that they had is the same notebook that we have here in evidence. It was marked for identification.
It was not marked.
It was marked for identification.
It was
Yes, letter P.
just for identification.
Just for
So
identification.
we know that the chalk that went into the jury room is the same chalk they had with them during the course of the trial.
To the best of my knowledge, yes, it was. There were several binders.
One for each juror.
One for each jurur.
All right.
One was marked. It may have been an extra one. I can't tell you specifically that particular binder went to a particular juror.
Okay.
But every juror had one, and then it was marked for identification.
Okay.
Just a few other comments. The Vance report talks about the co-DNA unit. I don't think it's fair to suggest it was the entire DNA unit. And that the comment the defendant places so much reliance on is hearsay. That there is that even if you were to wade through the relevance, the admissibility issues, this one comment is that certain unnamed sources thought that perceived that there was a use of corrective actions so that people that were perceived as incompetent or wanted were placed in either the CODIS or the co-DNA units. I mean, this is hearsay in its rankest form, and even if the report itself might be admissible, which the Commonwealth contests, that this is just a rank hearsay statement. And
Ms.
that
Alford,
this
are you going to talk about the closing argument?
I certainly can, Your Honor. The Commonwealth agrees that there shouldn't have been a comment that there was an answer for the jury, but says that there was no prejudicial error because of the context. And the context for this particular issue, particular comment, is extremely important. And that context was that in the opening statement, at the end, the defense counsel said that at the end of the trial, the jury was going to have to decide whether the Commonwealth got it right this time, which, in the context of what was reasonably anticipated to be shown at the trial, there was nothing wrong with that comment. There was a third-party suspect. The third-party suspect was called by the defendant as a witness. So certainly that would have been a comment for the jury to think about. But on that same line, there was nothing inappropriate for Commonwealth, the prosecutor, at the end, after summing up all the evidence, to say the answer is yes, we got it right this time. The person who murdered the victim is sitting right here. And now, well, the Commonwealth agrees that the part that there was an answer for family members or Ed Burke, or there also was an answer for the defense counsel, shouldn't have been said. That there was no asking the jury to decide for the family. I mean, the inference, certainly there was an inference, but there was no explicit request for the jury to do something. It is not, I suggest, unreasonable for the jury to have thought that this was the Commonwealth's answer to the defendant's question that he made in the opening statement. And so that I would point this Your Honors, particularly to Commonwealth versus Kent K. I suggest that case is very much on point. Here, and particularly how it contrasts Commonwealth Santiago. This was a case where there was overwhelming evidence, and not just because of the 1 in 268 trillion statistic, but also not only was the defendant's DNA there, but this was saliva, where the jury could have found that not only was his DNA there, but his DNA was attached to a saliva stain on the inside right cup of the victim's bra. There were 2 bite marks on the victim, one on each breast. The left breast, the Commonwealth expert said, I believe it was more probably the defendant, could have been made by the defendant, that the DNA, the predominant male profile on the cutting, from the cutting on the inside cup of the victim's bra was consistent with a minor male profile that was taken from a DNA swabbing of the victim's left breast, which was where the bite mark that was used for examination was. You also had evidence that he made statements to an inmate. You had a witness who testified that somebody that very much looked like him had been following him in the park. You had testimony that he had been a delivery driver, that he had fished in the area, that he had knowledge of the area of the park. And for that reason, the mistake in closing argument did not affect the verdict in any way. If there are no further questions.
Thank you, Ms. Alford.
Thank you.
We'll take a short break.